Hi, I'm Sam Butcher of Butcher Elder Law. We've noticed that when meeting with clients for the first time, sometimes they're confused about the difference between a last will and testament, a pour over will, and a living will. So let me take a few moments to clear up any confusion that might exist over the difference between those three types of wills. And I want to start with the living will. The living will is part of your healthcare planning. The living will is a document that addresses a couple of end of life situations. It's referred to, along with a healthcare power of attorney, as an advance directive. And it deals with terminal illness and permanent unconsciousness. And the definitions of terminal illness and permanent unconsciousness are included in the living will. And basically, this is a document that gives you the opportunity to tell your doctors and hospital administrators, family members, clergy, and others that you don't want to be kept alive if you've got a condition that's irreversible, incurable, and untreatable. You don't want your death to be prolonged if there's no hope that you can recover from this disease. So you want to be made as comfortable as possible. You'd like your pain relieved, but you don't want your death to be prolonged. Likewise, if you're permanently unconscious, if two doctors have examined you and confirmed that you're never going to wake up again, you can give the instruction in your living will not to be fed and hydrated through your veins just to keep you alive. And so what you're really doing when you execute a living will is relieving your loved ones of the burden of having to make a very, very difficult decision if you are in a situation where you're suffering from a terminal illness or two doctors have determined that you are permanently unconscious. You're saying to family and others, it's okay. It's okay to let me go. I wouldn't want to continue to be kept alive in this situation. Okay, that's the living will. What's a last will and testament? Well, a last will and testament is a document that allows you to pass on any assets that are titled solely in your own name at the time of your death to your intended beneficiaries, and also to nominate the individual that you are going to rely on to be your executor. And that's the individual that's going to be authorized to liquidate your assets, to pay the expenses of your last illness, any outstanding debts, or to challenge those debts and make sure that any debts presented are legitimate, and maybe negotiate debts if there is debt, and then to distribute the net proceeds of your estate after the sale of your home and other assets to your intended beneficiaries. Okay, and you can also include some provisions in the event you have a minor beneficiary. You can include a provision in the event that at the time of your death, you've got a beneficiary with a disability. And you want to make sure that that beneficiary doesn't lose any public assistance benefits they may already be receiving as a result of inheriting some money from you. So we include those things in the wills that we prepare for our clients. It's important to know that the only assets, though, subject to the will are those that are titled solely in your own name, with no joint account holder, no payable on death beneficiary, or no transfer on death beneficiary. Now, what about a pour over will? What's that? Well, for the clients for whom we create trusts, clients who have decided, hey, I don't want to use the state's rule book, which is a last will and testament subject to probate. I want to avoid probate. I want to create my own rule book. So I'm going to create a trust. Maybe it's an asset protection trust to protect property in the event they need long-term care. We create for those individuals with a trust-based plan a pour-over will. And this is something that we create just in case there's an asset that got missed. There's an asset when they die that's still titled solely in their own name. It's not in a joint account. It's not payable on death to the trust or to another individual. It's not subject to a transfer on death title of any kind. And so the pour over will has just one beneficiary, and that one beneficiary is the trust. So anything that would be subject to probate would pour over into the trust, because all of the client's distribution instructions, who gets when and what and how, are all going to be contained in the trust. Again, if we do our part and the client does their part, we can completely avoid probate. So the pour over will is sort of a just in case there's anything that does exist solely in the client's name at the time of death. So we'd be happy to further explore these subjects with you, help you with your own planning, make sure that you're planning and you are all set. And all you have to do is give us a call, 440-268-8284, and schedule an appointment to come in and meet with us. You can also visit us online at butcherelderlaw.com. Thank you.